everyone, and welcome to this edition of Shergroup on the Sofa. I hope wherever you are in the world today, you're having a good week. It's nearly Friday. I know I'm on countdown to the weekend. So with me today is my guest, Eve Lumsden, and she is an estate planning attorney and professional here in Florida. So I'm going to introduce her in a moment properly. But before we do that, we just want to give a shout out to our Shergroup's #1 fan, Mr. Ross Saunders, in Norwich, England, UK today. So hey, Rossi. And funnily enough, Eve is married to a Ross. So
I am. I think it's a fantastic name.
There you go. That's what my sister said. So there you go, Ross. Okay. So Eve, so nice to invite you onto our virtual sofa today and to talk to you about estate planning. Honestly, you're an estate planner, but you've got such a lovely demeanour. You wouldn't think that what you do is, it's got a sad tinge to it in a way, but it's pragmatic, obviously, what you're doing. So, and it's very, very important. And I think the more that we hear from you, the more that we understand why it is so important within the state of Florida. So I wanted to get into that today. So I guess a #1 question really is, I mean, why do people need an estate plan? And do they need one even if they're not rich?
Well, first, Claire, thank you. Yeah, so thank you for having me. And the short answer is yes, every adult needs an estate plan, because an estate is not just millions of dollars of accumulated wealth. Your estate is any asset that has value to you. So whether that is your bank account, even if there's $100 in there or if there's $1 million in there, it is the inherited jewelry that was passed down from your mom or your grandmother. So the estate planning isn't just for wealthy individuals, because wealth is subjective too. It is to protect what is valuable to you. And anybody over the age of 18 should have their estate plan in place, because the younger you are, the more chance your estate's going to grow. And hopefully, if you're 65, your estate is still growing. So there's always the chance that you could become wealthy too, and then you need it more than ever.
Yeah, I see the value in that. So to those people that you must meet in your journey who say, well, can't I save money and do it myself online? What do you say about that?
So I actually just met with a married couple last week, and they had done their estate planning online. And it wasn't bad, but it didn't achieve the goals that they really wanted to achieve. The online tools are very basic. Usually they try to be state specific, but the websites don't always keep up with the changes in state law. So for example, Florida requires that your last will and testament be witnessed by 2 witnesses, that it be notarized, that the testator, the person making the will, has to sign at the end of the document. And so a lot of those components are captured online, but what's not captured is that Florida implemented a affidavit at the end of your last will and testament that negates the need for the witnesses to your will to actually go to court later to do what's called proving your will. So these online estate planning tools usually don't have that affidavit. Some of them miss the areas for individuals to put specific wishes for guardianship for their minor children. And so there are a lot of pitfalls for do-it-yourself planning, where if you execute the documents properly, they may cover your estate in some areas, but there are usually large gaps, and that can be detrimental, and your estate may not be administered the way that you want it to, despite your best efforts. It's always best to talk to a professional.
I mean, really, what you want if you're not there anymore to be able to guide people is to make sure that your estate is being handled by the right people that you picked and not who the law is picking, right? I mean, I hear this, and I know that you've talked about it in networking sessions that we've been in, but I'm sure that the question is said to you, well, can't my family just take care of my children if something happens to my spouse and I? I mean, obviously you want your children looked after by whoever you pick, not by who the law picks. So who is going to look after the children if you don't make a plan for that? I mean, that's probably the thing that people should be thinking about the most, I would have thought.
That is always a big consideration for anybody with children. I have people whose children are over the age of 18 who come to me and ask me, can I nominate a guardian for my 21-year-old because they still need to be looked after if I'm not here. So it doesn't matter how old your kids are, they're always top of your mind. And so that is a huge consideration in planning.
Yeah, big kids as well, not just little kids.
Yes. Right? Children are our children forever.
Yes, of course. So if they don't have a plan in place, who will? Let's talk about young children. What would happen? Yes. What would the state do with young children if there wasn't a plan in place?
Right. So if it's a married couple or if it is a single individual, as long as the second biological parent of the child is still alive, the court is going to look at that individual to take guardianship of the child first. But when I say this, emphasis on the court, right? There's going to have to be some sort of court proceeding. Typically, it's called a guardianship for minors, so that the court can oversee who's going to take care of the child, because the court wants to make sure that whoever does so is the right individual, is capable of caring for that child correctly. So biological parent that is still surviving is usually the first choice, but that individual may not be the right person. They may have substance abuse issues. They may be incarcerated. They may be incapacitated and simply not able to care for the child. So then the court is going to look at immediate family members, people in the geographical vicinity, and take a number of factors into account. Somebody can step up and volunteer, but again, they have to petition the court through a guardianship action. All of the court proceedings, family law court dealing with minors is probably one of the most gentle courts there is, but it still can be traumatic for a child going through these adjustments and going through these cases. And sometimes the child is present for these proceedings and it can be tough on them. That's why we want to make sure that we have a guardianship in place in case anything happens to the parents. We want to make this process as easy on the children as possible. And we also want to make sure that they are being cared for by somebody that they are going to be comfortable with, feel loved by, and just know that they are set up for their future.
Mm. And what about the cost of those proceedings for guardianship? Where does the money come to pay for that decision? Guardianships are expensive. They are one of the costlier court proceedings for a number of reasons, just by virtue of the nature of the proceeding, by how much continued follow-up and reporting has to happen with the court through a guardianship proceeding. And so the money is going to come from a couple of different places. The estate of the deceased individual can pay for the guardianship, and frequently that is going to be part of it. But again, if there's no assets, right, then where does the money come from? So then you're looking at the individuals who are stepping up, who want the guardianship of the minor child. But again, when you compare, say, a probate to a guardianship in terms of cost, probate is really structured based on statutory recommendations, industry standard, but guardianships are so detailed and so involved and can be very time consuming, not just for the proceeding itself, but again, for the follow-up that has to be delivered to the court, that those are usually an elevated cost. And so the estate bears the burden of that. You're taking assets away from the care of the minor child to pay for that proceeding. So it can be devastating. Are we painting a picture here, everyone, for why Eve's advice is so necessary to not only keep you out of court, but also to save you a lot of money? in unnecessary, really, you know, it's unnecessary cost if you get your planning in place, you know, at the right time. So, so another question you must get asked is, okay, well, if I make a will, is Florida State going to get my assets anyway? You know, is what happens in that scenario? Do people ask you that?
Absolutely. It's a common misconception that the state of Florida wants your assets. Florida doesn't actually want your assets because, well, for a couple of reasons. They don't want to have to manage your assets. They don't want to have to pay to store your assets. And if 5 years after they took control of your assets, some beneficiary or heir of the estate came back and tried to rightfully claim those assets, well, then they have to give them back. And that's another burden, another cost, right? So Florida really doesn't want your assets. But Florida does want to ensure that your assets are distributed properly. And there are many, many laws around how those assets are distributed. And so the benefit of having an estate plan in place is when you work with a knowledgeable attorney, they understand the laws. They're going to craft your plan that is in accordance with the law and make sure that everything you're doing is something that if the court were ever involved, the court would look at your plan and say, yes, this is 100% proper. I'm going to stay out of it as much as possible and just let this estate be administered. So that is really the goal of the client and attorney relationship when you're crafting your estate plan. The client's goals are typically protecting assets, protecting minors, tax planning, making sure that you're paying minimal taxes and your beneficiaries are paying minimal taxes. And your attorney is there to make sure that the state stays out of your estate plan as much as possible and that all of your personal goals are met. So a knowledgeable attorney is going to help make sure that the state itself is involved in your estate the least. Now, there are times where having the state involved is going to be a benefit. And I tell clients this all the time. A lot of clients want probate avoidance. If you have a large family with a lot of beneficiaries and you know that they fight and you know that they like money and they're waiting for an inheritance perhaps, that's when a probate could be beneficial because you get a court order from a judge that states how your estate is going to be distributed. That court order is really set in stone, right? The beneficiaries listen to that. Most times they respect it. They don't fight it. They don't litigate against it. So I tell all of my clients, there are times where probate is a benefit, but usually not for everybody, not for the me's and the you's of this world.
Okay. Yeah. So again, talking to someone like Eve and crafting that plan that's right for you and your situation, I think, Eve, isn't it? Because everybody's individual. And every
yes.
family and every business comes with its own nuances. So don't leave it to chance, I think, is what Eve is saying throughout her responses. Get a plan in place. So I use an expression that comes from England. You guys here in Florida say, I think, kick the bucket. We say in England, pop my clogs. Both of them the same thing when I die, right? So, which, you know, none of us want to dwell on that, but so there's two things certainly in life, right? Taxes and death. So yes. What does the estate plan cover when somebody passes? What does it cover?
So a good estate plan should be comprehensive. So the estate plan is going to typically list your wishes for disposition after you pass. So the estate plan is going to start as soon as you pass away. Your powers of attorney, your living will, those are the documents that control while you're alive. Your last will and testament, your revocable trust, any irrevocable trust, your pour over will, those are the documents that take effect as soon as you pass away. Those are going to be a good roadmap for the people that you leave behind. So again, they can cover your disposition wishes, cremation, burial, memoriams, anything that you want to list in there, you can. And those are also going to help your agents and your representatives understand what they need to do according to your wishes right away. they're going to allow your successor trustee or your personal representative to take control of all of your assets, real property, your home, your investment properties, businesses, and your personal property, and ensure that it's protected so that it can be distributed according to your documents, according to your wishes. And so the more comprehensive your documents are, the better the roadmap for that personal representative or that successor trustee. They're going to understand what their responsibilities are, how to take control of your assets, how to distribute your assets, and to whom. But good documents, they're going to start with guidelines for that individual from the second that that individual assumes their responsibility, which is going to be as soon as you pass away. So it's going to be a comprehensive plan from start to finish. I always recommend to my clients as we're executing their documents, let's sit down with the people or person that you have named as your personal representative, your successor trustee. Let's talk to them and give them a preliminary idea of what their responsibilities are going to be so that they know, so that they are connected with me, so that when the time comes, they will reach out to me if they have specific questions. I can help guide them through the administration process, but so that nothing comes as a surprise to them. And that way, if there's anything that we think of along the way that we need to add, whether it's for the peace of mind of the client or the peace of mind of the personal representative, we can make sure that there are no gaps in that plan.
Yes, very sensible. So husband and wives, you're going to have to sit down and work it out. Maybe you didn't
and if they say that they've named an adult child as their successor trustee when the second of them passes, well, a lot of times the husband and wife, they put that plan in place, but the adult child who's named, they know they're named, but they have no idea what that means. And so it's nice to give them a sense ahead of time because they're going to be grieving while they are administering the estate. So it's nice to help them in the beginning through the process.
Yes, yeah, I understand that. I know this, as many people listening to this will know, because my parents never discussed their wishes really with me and my sister, and very, very hard to then second guess what either of them wanted. And it's an uncomfortable subject. I think that's why talking to Eve, I think, is such a positive, making something that is difficult easy, having somebody easy to talk to.
Thank you.
So the word probate, now that's a technical legal term. What does it mean, for folk listening today here in Florida? This, I must remind you all, is just for Florida, right? We don't work outside of Florida.
Right. I am Florida licensed. So probate, it's the P word. It's a lot of people think that it's a dirty word. It's a horrible word. And like I mentioned earlier, there are times where probate is a good thing. But ultimately, probate is the court supervised process of estate administration when you pass away. And that's the legal way of saying where all of your stuff goes and to whom, and to ensure that your distributions comply with Florida law. Because as I mentioned, there are a lot of them about your estate distribution. But essentially, if you pass away, even if you have a last will and testament in Florida, that last will and testament is likely going to need to go through probate. And so your personal representative or an interested party is going to have to open up a court case in the probate court of the county where you resided when you passed away. And depending on the value of your assets and how many creditors, how many people you owed money to when you passed away, is going to determine the type of probate, because Florida has two, technically three, but that third one isn't used much. So probate is, like I said, it can be a 4-month process. It can be a 2-year process. It just depends on the value of your assets. A will has to be deposited with the clerk of court in the county where you resided by law within 10 days after you pass away. And that will, if you pass away with a will, is what's going to guide the probate. Now, if you pass away without a will, then Florida law is going to step in. It's called Florida's intestacy laws. And those are those laws that I referenced that dictate how your assets get distributed and to whom. They also dictate the time frame of your probate. There's a whole code around it. But essentially, you will most likely have an attorney working with one of your beneficiaries or the personal representative listed in your will to ensure that the court case proceeds according to Florida law, to ensure that your assets get collected and protected right after you pass away and then distributed. The difference between having a will and passing intestate means that as long as the will is not invalid or does something contrary to Florida law, the will is going to dictate how your assets get distributed. So it's beneficial to at least make a will to make sure that your wishes are upheld when you're no longer here to give voice to them, to make sure that your inherited ring, your family heirlooms, your very valuable assets go to the individuals that you want to have them. Otherwise, Florida law is going to tell you where they go, and that might not be what you want. So a will is a great thing to have. A trust is a completely private document. A revocable living trust never gets deposited with the clerk of court. By law, it doesn't have to. It's the best vessel for probate avoidance in Florida. Not right for everybody. It is very appropriate for most. And we can get into that more in detail later. But those are kind of the nuts and bolts of probate. Most likely you pass away without a will, there will be a probate. If you pass away with a will, probably still be a probate. If you pass away with a trust, perhaps not.
We'll look at that. So there are two things certain in life: death and taxes. So will the estate have to pay taxes when a person dies in Florida?
Well, Florida is great in a lot of ways. And one of them is Florida does not have what they call death tax or inheritance tax, which is fantastic. Now, if your estate is still valued over the federal estate tax threshold, then yes, your estate will have to pay taxes. As of 2024, that threshold is over $13 million per individual, and you can combine it to make it over $26 million for a married couple. So many married couples in Florida do not reach that tax threshold. Now, that law that has that threshold so high is going to sunset in January of 2026. We don't have a crystal ball, and we don't know what those numbers will come down to. But we do anticipate that they will come down. It could be $5 million per individual. It could be 10. There's a lot of projections, but again, we're just kind of at the mercy of those who make the law. So right now, most clients do not qualify for estate tax. There is no estate tax, no inheritance tax in Florida, and that's a beautiful thing. Beneficiaries may have to pay taxes on real estate that they inherit if they sell the real estate. So that's capital gains tax. That's a whole different ball of wax. But again, the law has been structured to make the taxes that beneficiaries pay on real estate that they inherit and then sell as favorable to those beneficiaries as possible. So that's one way beneficiaries may end up having to pay tax, but no estate tax, no death tax on inheritances in Florida. So that's great.
That's why I moved to Florida. The situation is very complicated in the UK. So if any of you are listening from the UK and are thinking about coming to shift to Florida, then there's another good reason to do that. I think that's fair because it means that people that have, accumulated wealth, not huge wealth, but, a significant amount of wealth are going to be able to pass that on to their family without fear of it being taken by the government.
Absolutely.
So that's great to know that that happens here. So, so we're gonna look at trust in a moment, but in terms of nominating people to administer the estate, what do you recommend to clients? Do you recommend adult children, or who who's the pick really for the person that's going to take the this on their, you know, on their shoulders in terms of looking after your estate?
Yeah. So it's subjective. And the reason it's subjective, if it's a married couple, typically your spouse, you're going to nominate your spouse first, just because most of your assets are jointly held. They already have control over them. You want your spouse to have your assets. So typically a married couple, spouse first. Not always, though. And it doesn't have to be your spouse. In terms of successors, who's going to administer everything after the second of you passes, or if you are a single individual, that's going to be subjective. You want to make sure that it's somebody who is going to have the emotional fortitude to administer your estate, because there's a good chance that they're going to be grieving for you at the time that they are administering as well. You also want to make sure that it's somebody who can handle that level of administration. This is why I think it's a good idea to talk to people that you are considering making your successors ahead of time. It can be a trusted friend. I have a lot of elderly clients who have outlived their spouses. Their children are across the country or across the world, but their next door neighbor is like a sister to them, is like a brother to them, and is 20 years younger. And so they say, well, you know, should I name this person? They're not my family. Well, it's really not about their relation to you as long as they're in the state of Florida, because again, there are guidelines and laws around who can be a personal representative. But as long as the individual that you're considering nominating meets those criteria under Florida law, it's really about who is the person that you trust the most to do exactly as your documents state, that is not going to just skim a little off the top, right? Take a little bit of a fee for doing all the work. And you want to make sure that it's somebody who is able to manage, because there will be other areas that they may want help in. So for example, filing that final tax return on behalf of the deceased individual. They may be personal representative or successor trustee may need to hire somebody to do that. Right? So you want to make sure it's somebody who can meet all of those necessary items and action items. And so there's a lot that goes into consideration for who that is, but it does not have to be an adult child. Can be, but it doesn't have to.
Okay, well, that's good to know, because for some people that's not the best choice. And I like the idea of the trusted neighbor, you know, particularly, as you said, you know, we're all living longer, hopefully, and you know, we can outlive our spouses, and as I say, children move away, and they're just not around the corner anymore. So I think, you know, for elderly people listening to this is good advice.
Yeah, and if you did want an adult child and they don't live in the state, that's fine too under Florida law. If the individual that you want to nominate is not a Florida resident, you just have to make sure that they are a spouse or a lineal descendant or the spouse of a lineal descendant, meet those legal criteria. So it doesn't have to be somebody here in the state of Florida, but talk to your attorney just to make sure that the person that you're nominating, if they're far away, that they do meet the criteria.
Of course, yeah, of course. So we were talking about, I think the phrase you used was probate avoidance. I don't think that was meant in a bad way. It was meant to be a practical avenue, really, to avoid the estate going to probate. So what can a person do in their lifetime to organise their affairs to avoid probate quite lawfully?
Yep. And probate avoidance is a goal of many clients of mine. And the reason why is because probate, again, it's a court cost. Usually there's attorney involved, and there are going to be fees, right? Those assets come out of the estate typically. And so they drain the assets that you are leaving behind for your beneficiaries. So again, probate it's not the worst thing, but if you can avoid it, a lot of people want to. And there are good ways through your estate planning to ensure that you do avoid it. So first and foremost, any asset in Florida that has a transfer on death or pass on death designation. So where you can list a beneficiary, those assets are going to pass by that beneficiary designation when you pass away. So retirement accounts and 401ks, those things have the option of listing one or multiple beneficiaries. Make sure that you're keeping up with those. If they don't have any beneficiaries, go in and add them. If they do have beneficiaries, but your wishes on who would inherit have changed since you initially designated, go in and update them. And I recommend updating every couple of years or when a big life event happens. Just keep your plan in mind. Don't do it and then forget it, because your life changes. So your plan should change. So that's one good way to make sure that those assets avoid probate, because I should go back and say, any asset that you have that is titled only in your name and does not have a beneficiary is going to require a probate case, because the court needs to make sure that that asset gets distributed to the right person, doesn't sit for 10 years undistributed, right? So that's the goal of probate. So you want to make sure that you're putting beneficiary designations on everything you can. And a lot of my clients don't know that you can put beneficiary designations on your bank accounts. So if you and your spouse are joint account holders, great. When the first of you passes away, the second of you owns that account. But where does that account go when that second individual passes? Probate. The banks aren't just going to let somebody come in and get into that account. Put a beneficiary on your bank account as well. So you can do that, and then that will avoid probate as long as you're updating the beneficiaries. So that is one good way. The other big avenue that a lot of my clients choose is a revocable living trust. You can create one for two married individuals, or you can create one just for yourself, or married individuals can each have their own as well if they have a lot of individual assets. But the trust is a completely private document. As I mentioned before, it doesn't get deposited with the court. It doesn't have to by law. And so what happens in the trust is, if you think of the trust like a bucket, and you're creating this bucket and you're titling your assets into the name of the trust. So you can place your homestead in the name of the trust. You can name your bank accounts in the name of the trust. You, who is creating the trust, have all rights, title, and control over all of the assets that you place within the trust, the same as you did before you created the trust. Only now, when you interact with those assets, you're interacting as trustee of the trust, not just yourself as an individual. Well, within the trust, you name a successor trustee for when you pass away. And as soon as you pass away, that successor trustee comes in and is authorized by law to take control of your assets and to start distributing them according to the terms of your trust without having to ask the probate court's approval to do so. So you can see right off the bat that that's a huge benefit, because you're not having to go open probate, wait for a court order, have your personal representative appointed. This successor trustee just automatically comes in and starts administering your estate with legal authority to do so. So that's one reason why most of my clients choose a trust over just last will and testaments, because probate avoidance is a huge concern, and you're avoiding draining the estate assets by having to pay for a probate.
And again, technical, you make it sound very easy, but it's got to have the skill and expertise of someone like Eve to guide you through that process. So again, don't go and look this up online and try and do your own. Really.
And to add to that, Claire, one of the things that is really technically difficult for most of my clients is homestead. Florida has those great homestead laws. Like I said, we're great about a lot of things, and Florida has those homestead protections and home tax benefits for most of my clients and for most of its residents. But there are also a lot of laws around how your homestead can be devised. So when you are married, you cannot devise, put into a will or a trust or an estate plan, your home is going to go to anybody but your spouse. If you're married with minor children, you can't devise your homestead to anybody else, because the Florida law is crafted to make sure that surviving spouses and children do not become homeless, do not get disinherited. So when you're crafting an estate plan, you have to take those laws into consideration as well, because what's most clients' most valuable asset? your home, especially right now.
Yeah.
So yes, do not look everything up online and try to go it alone, because Florida makes that difficult, if not impossible.
What sort of cost for maybe for an average client? I mean, I know it's subjective, but can you give people a kind of ballpark of what an estate or an irrevocable trust kind of exercise would cost them, just so they're not completely, thinking, having nightmares about what the cost might be?
Sure. Yeah. And again, everything is subjective. I think a lot of clients are surprised, right? A lot of clients, if they go online and they try to do the DIY estate plan, they're going to look at a couple $100 to $1,000. And they're going to say, all right, great. So if I hire an attorney, this is what I should be paying: $500 for my revocable trust and pour over will and all of my lifetime documents. They get surprised by the cost. But I think if you listen this far, you understand the complexities, you understand the knowledge and the skill that has to go into making sure that your plan is crafted correctly. For a married couple, the plan for a trust-based plan, it can go up to $4,000, $5,000. That's average market pricing in the Central Florida area right now. But you have to think that that's going to include over a dozen legal documents. It's going to include hours of consultation, fact finding, asset finding, digging with your attorney, between the attorney and the clients. It's going to involve all of the laws that are going to be drawn into your documents, the roadmap that it's going to leave behind for your agents, for your successor personal representatives and trustees. So clients come and they frequently get shocked by the cost, because again, I'm saying up to $4,000, $5,000 for some of the more complex planning. It can be less than that, absolutely. But it's rare that clients just come in and don't have a question on the pricing, especially if they've priced things online. But again, if you consider the fact that a probate is probably going to cost you at least that much, and if not more, because statutorily, attorneys can be awarded a percentage of the value of the estate asset. So if you have a higher value estate, some attorneys, I think $10,000, $20,000, up to $100,000 awarded to the attorney through a probate. So it's one of those things that the cost benefit analysis of getting a solid plan in place now that's going to require, again, minimal supervision, possible amendments through your lifetime, but not a great deal unless you have something catastrophic that changes. This plan is going to live with you for the next 10, 20, 40 years, however long you're around, hopefully a good long time.
Yeah. No, I see the complete value of everything that you're saying. Just keeping it simple. Obviously, there has to be a bit of digging into the assets that you've got available. People probably haven't even got a full list of what assets they actually have got. I think I heard you in another meeting today, and you were talking about digital assets and what happens to those. So it's if you've got a website where you're doing a lot of business. And you run the URL for that website, it has a value. You've got an online business, that has a value. So, yeah, I mean, definitely just getting everything on the table with you and saying how you can protect it, I think is a really good idea. In terms of that, someone comes to you, you have probably a checklist of the documentation you're going to need from them for all their various assets in their various shapes and forms. And is that it? Is it? I can't imagine. I think you just said it's going to still have changes, but it's not. I mean, I guess it's a one-time thing to get the paperwork in place and kind of down in terms of a plan. But then I guess as things change in people's lives, that plan gets updated and reviewed.
Yep, it does. And because life is not static. So I had mentioned earlier, the clients that I met with that did their online estate planning. And so there were definitely some fatal flaws in the documents that needed to be redone, right? So going back to the cost, you think, okay, I'm going to do this once. There's value in what I'm paying for. If you do it yourself, there's a good chance you're going to have to pay for it twice, right? So do it right the first time for sure. Save yourself the stress and the headache but yes. So again, as life changes, so if you're a married couple and the first spouse passes, you're going to want to revisit your plan. You're going to want to make sure at that point in time you're looking to see, are all of my beneficiaries updated? Was my spouse my only beneficiary on this account? Should I be putting now my children or my nieces, my nephews? And so big life changes necessitate a review of the plan just to make sure that your plan still comports with your wishes. But again, those are going to be hopefully not frequent, right? Big life changes, good or bad. Sometimes a lot of them can be too much. So we want to make sure that every now and then when those big life changes happen, we're reviewing, making small possible necessary amendments. And then that should be it. Again, your plan is going to live, grow, and change with you. It should stay top of mind, but mostly for the peace of mind that it provides. And when it stays top of mind and gives you that peace of mind, then when something happens in your lifetime that you understand should trigger a change to your plan, then you know right away, okay, I'm going to pick up the phone and I'm going to call my attorney and we're going to make this amendment, or I'm going to change this beneficiary. It's quick, it's easy, and you can go back to life as usual, just knowing again that all of your wishes are in place.
Brilliant. Okay. So some very sage advice there from Eve. And honestly, if you wanted to go and talk about these sometimes difficult subjects that we all have to face, then how nice to be able to talk it over with a nice, friendly attorney who's, just looking after you and what you want to achieve. When we all kick the bucket, pop our clogs, right? I mean, that's what it's all
I love
about.
your saying better.
I don't know where it comes from, but that to the Brits out there, don't understand it. So thank you, Eve, so much for guesting on this show on estate planning and what to do with your estate in Florida. Eve's contact details will be in the show notes. She has her website, lumsdenlawfirm.com, but you can also connect with her on her growing LinkedIn community. She has a Facebook page and an Instagram page, so she's got every channel open to you to whatever's your favorite channel. She should be able to connect with you. I don't think you've got TikTok yet, but maybe you're working on that. I don't know. But she's got plenty of channels out there. So thank you very much, Eve. For everyone else tuning in to Shergroup on the Sofa, thank you so much for your support of our interview TV show. We love talking to different business people and shining a light on different things that we think impact our community. And obviously we have a community here in Florida, which is where we're based most of the time. So thanks for staying with this episode of Shergroup on the Sofa. You can visit our official website, shergroup.com, and you can see updates on all the solutions that we have for our growing community. And like Eve, you can follow us on Facebook and Instagram, LinkedIn. We'd love to see you. And you can subscribe to this podcast. So please subscribe, click the notification bell, and when I have a new video come up, then you'll get notified. And you can also listen to this interview on podcast if audio is more your thing than video. So until next week, thank you very much, everyone. Eve, thank you so much for being such a gracious guest. Lovely to see you.
Thank you, Claire.
And I'm sure we'll talk again in the future. So keep us updated on what's happening on Florida estate law and how you think you can help our community. I'm sure people would love to hear from you. Okay?
I will. Thank you so much, Claire.
Bye-bye, everyone. Bye-bye.